Are you concerned that you've run out of time to hire a lawyer for your birth injury case? Stay tuned.
Welcome to the YouTube channel of Michael J. Swanson. Michael is the author of How David Beats Goliath and is the CEO of Advocate Capital. And now, here's Michael.
Nelson, thanks for joining us today.
Hey, I'm glad to be here.
Well, I know you to be an expert in the area of birth injury cases, analysis of cases, and helping families. And one of the things that they might not realize is that there are statutes of limitations for bringing cases. So how does that work with a birth injury case?
So in every personal injury, there's a statute of limitations. There's a timeline within which you have to bring the case or you lose the opportunity to bring it ever. In birth injury cases, there are varying timelines. In the state of Georgia, let me talk about that one. There are actually two statutes of limitations. Georgia divides the claim between the parent's claim and the child's claim. And so past medical expenses would be the responsibility of the parents for 18 years, right, until the age of majority. And so that part of the claim, the past medical expenses for the first 18 years, are brought by the parents, and that's a 2-year deadline, 2-year statute of limitations. The second part is the child's claim, and that's everything other than the past medicals. So future medicals for the rest of their life and care, rehabilitation, lost wages, lost income, and then what some people call pain and suffering or loss of capacity. That all belongs to the child. Thankfully, in Georgia, there's an additional 5 years on top of the 2, so 7 total to bring that claim. And so sometimes parents get to us in that 2-year window. Sometimes they don't. Sometimes they've been using all their time and energy just to take care of their child.
Sure.
And that first claim is waived. But it's really the child's claim that tends to be the larger of the two. And we routinely go forward even when that first 2-year period is passed.
Wow. Wow, that's interesting that it's the parents for the first 18 years, they're responsible for the past medical.
Right, it is. I'm thankful in Georgia that at least we give an additional 5 years for the child's claim, because the truth of it is that with the kinds of kids we represent, they're all profoundly brain injured. They're all profoundly developmentally disabled. It's a huge full-time job for the parents just to take care of them. And so the last thing that families have the time to do or the brain power to do is to think about contacting a lawyer and getting to the bottom of whether maybe the hospital and the doctor are responsible. And so it's just practical and merciful that you give the families longer than 2 years, which is what they would have in a normal personal injury case. I wish it were longer. In some states, it is longer. It would make more sense, and I hope the legislature changes that one day.
Well, if someone watching this had questions about what maybe their child is not developing certain milestones or about if they have a case or not, how would they reach you?
Well, the two best ways to reach us are they can call us at 404-377-0017, or they can contact me directly at Nelson, Nelson, at TyroneLaw.com.
Fantastic. And you've told me before that there's no charge if someone just has a few questions for you.
No. We review cases and there's no charge at all for our review. And the only charge is if we review the case and are able to take it on, and we're successful.
Got it.
Any time that anyone pays anything at all.
Wow. Well, thank you for what you do in your community and for helping people with these important issues.
I'm really proud to do it. Thank you.
Thanks for watching. Send your questions or comments to Michael at mike@howdavidbeatsgoliath.com.